Hello, everybody, and welcome to History/Law Bite number 283, dated June 28th, 2021. I'm Walter, your mobile historian and blue-collar scholar. This History/Law Bite is entitled Hollingsworth versus Virginia, 3 U.S. 378, 1798. Thanks so much for tuning in. This was another U.S. Supreme Court decision handed down in the first decade of its life, in an era where the power and prestige of that institution was almost non-existent, and its authority quite often disrespected. All right? Like I said, in this era, it was very difficult to even get people to serve on the Supreme Court. Okay, and that's most men of prominence would have rather had accepted positions in other high offices than be a Supreme Court justice at that time. That just lets you know how, little value the court was seen to have had in this era. So this is going back to 1798, all right, and we're in, a very, contentious period in the United States history. John Adams was the president, and we were engaged in the quasi-war against the French. All right, and this is the era where political parties, are really taking form and, causing the division and polarization that we're all too familiar with today. Okay, just to give you some context and background. All right. So we begin this case as all U.S. Supreme Court arguments begin. All right. All rise. The Chief Justice and the Associate Justices of the Supreme Court of the United States. Oyez, oyez, oyez. All persons having business before the Honorable, the Supreme Court of the United States, are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Please be seated. Mr. Chief Justice, and may it please the court, we now dive into Hollingsworth versus Virginia. So, Hollingsworth versus Virginia was a very significant decision that spoke on the constitutional amendment process and whether or not, a particular amendment, the 11th Amendment, was validly ratified, and if there was any presidential role in the adoption of the amendment, which was later found, of course, by the plain language of the Constitution to be non-existent. Okay? So that was essentially what the court gave us with Hollingsworth versus Virginia, all right, and the applicability of the 11th Amendment to existing and future lawsuits. So in this case, all right, we see our petitioner, Levi Hollingsworth, all right, who was a Pennsylvania merchant who owned quite a bit of shares in the Indiana Company, all right? Back then, these companies existed largely in the land speculation trade. And, here we see the Indiana Company seeking to resolve a dispute over a land claim in Western Virginia, part of what is now West Virginia. But of course, West Virginia did not exist at this time, of course. So it was in far Western Virginia, all right? And they needed to resolve a land claim. So here, our petitioner Hollingsworth actually replaced, a previous plaintiff named William Grayson, okay? And the change was due to the Supreme Court's decision in Chisholm versus Georgia in 1793, which, the court gave its blessing for a state to be sued in federal court by a citizen of another state. All right, that decision was very, very, very unpopular and prompted the Congress to propose what is now the 11th Amendment to the U.S. Constitution. Chisholm versus Georgia was the very first Supreme Court decision that was overturned by a constitutional amendment, and it was the very first Supreme Court decision that provoked a constitutional amendment to reverse its holding. All right? So, thus, Hollingsworth was of another state. All right, like I said, he was a Pennsylvania merchant, and Grayson was from Virginia itself. All right, which explains why you have the plaintiff change here. Okay, and with that in mind, we see that on the 8th of January, 1798, President John Adams formally announced the adoption of the 11th Amendment to the Constitution, which formally overturned the Supreme Court's decision in Chisholm versus Georgia. Okay, so that said, the suit, would officially be barred by the terms of the 11th Amendment, which gave rise to the legal issues presented to the Supreme Court in this case. All right, so the attorneys for Hollingsworth would argue that the 11th Amendment had not been properly proposed, as it had never been submitted to the President of the United States for his approval, either signature or veto, all right? But it was merely passed by Congress and sent to the states, okay? That argument thus strongly contended that the President had a direct role in the constitutional amendment process. And because he had been left out, the whole 11th Amendment was unconstitutional. All right? Trying to figure out exactly where in the Constitution, which I know very well, he's basing that argument. All right? Because the Constitution doesn't give the president any role in the amendment process. But I digress. So the Attorney General, all right, arguing on the opposite side, contended that, all of the other amendments had been adopted in the very same way that the 11th Amendment had been adopted, and there was absolutely no question to their constitutionality. All right? Also, the amendment clearly applies not only to future cases, but existing ones as well. All right? Lastly, the president's veto power was only applicable to ordinary legislation, all right? Thus, he's arguing that the president has no formal role in the amendment process, all right, to adopt the U.S. constitutional amendment, a process which is governed by Article 5, okay? Now, the Attorney General is presenting correct legal arguments to the Supreme Court, all right? And the attorneys for Hollingsworth are arguing something entirely made up, not supported by anything in the Constitution. So thus, presenting the issues before the Supreme Court, they had to consider, was the 11th Amendment validly ratified, having not been presented to the president for his signature or veto, okay? And they also had to consider whether or not the 11th Amendment applied retroactively to suits that were filed before it went into effect, all right? And the Supreme Court, unanimously would decide that the 11th Amendment had not only been validly proposed and adopted, but was also applicable to all existing suits that had been filed before its adoption and to all future cases as well. All right, it's a very short synopsis that the court gave, largely due to the fact that the Constitution speaks for itself on this subject. Okay, so allow me to enlighten you. Let's start with Article 5 of the Constitution, which discusses the amendment process. It reads, "The Congress, whenever 2/3 of both houses shall deem it necessary, shall propose amendments to this Constitution, or on the application of the legislatures of 2/3 of the several states, shall call a convention for proposing amendments, which in either case shall be valid to all intents and purposes as part of this Constitution when ratified by the legislatures of 3/4 of the several states, or by conventions in 3/4 thereof, as the one or the other mode of ratification may be proposed by the Congress." Did you hear anything in there about the president? Me either. Okay? So, again, that part speaks for itself. So where the attorneys for Hollingsworth wanted to put the president in there and having a formal role, your guess is as good as mine. All right? So let's read the 11th Amendment, which was adopted in 1798, having been proposed, in 1794. The 11th Amendment reads that the judicial power of the United States shall not be construed to extend to any suit in law or equity commenced or prosecuted against one of the United States by citizens of another state or by citizens or subjects of any foreign state. So basically, translating that into modern language, the 11th Amendment bars the use of the federal courts for the purposes of taking a state to court by a citizen of another state, and that prohibition was extended to citizens of one's own state, taking your own state to court in federal court in Hans versus Louisiana in 1890. Okay, and that also technically applies to foreign nationals taking a state to court in federal court. All right. So, but basically, you know, the original intent and purpose of this was to prohibit a U.S. state, all right, from being sued in federal court by a citizen of another state, thus preventing, example, New York from being sued in federal court by a citizen of Florida. Okay, so the 11th Amendment, you know, is, you know, controversial of and in itself. It's protecting the sovereign immunity, okay, of states, all right, and you know, its power, like I said, was substantially expanded with Hans versus Louisiana in 1890. All right, not only prohibiting citizens of another state from taking a state to court in federal court, but also extending it to a citizen from taking their own state to court in federal court. You know, unless under certain circumstances. Okay, there are always exceptions. Let me be clear about that. The 11th Amendment is not a blanket prohibition, and especially by way of the 14th Amendment, adopted many years later, of course, Congress is certainly able to abrogate that 11th Amendment immunity, as it is known, in a litany of different circumstances. All right, so that's the 11th Amendment. I did a video on it. Check it out. Okay, so let's read the court's opinion. Like I said, this was a unanimous decision, and this just gives you an overview. All right, like I said, the court held that not only was the 11th Amendment validly adopted, but it also applied to all suits filed before it was adopted and all future cases as well. Okay, so it says the amendment of the Constitution of the United States by which the judicial power of the United States was declared not to extend to any suit commenced or prosecuted by a citizen or citizens of another state or by foreign subjects against a state prevented the exercise of jurisdiction in any case past or future. Okay, thus applicable to past and future cases. The decision of the court in Chisholm versus Georgia produced a proposition in Congress for amending the Constitution of the United States according to the following terms. The judicial power of the United States shall not be construed to extend to any suit in law and equity, commenced or prosecuted against one of the United States by citizens of another state, okay, or by citizens or subjects of any foreign state, okay. The proposition being now, that's the language of the 11th Amendment, by the way, the proposition being now adopted by the constitutional number of the states, Lee, Attorney General, submitted this question to the court, whether the amendment did or did not supersede all suits depending, as well as prevent the institution of new suits against any one of the United States by citizens of another state. The court, on the day succeeding argument, delivered a unanimous opinion that the amendment being constitutionally adopted, there could not be exercised any jurisdiction in any case, past or future, in which a state was sued by the citizens of another state or by citizens or subjects of any foreign state. Okay? So the court is making it emphatically clear that not only was the 11th Amendment validly adopted, as it was done, as all previous amendments before that had been adopted, but it was applicable to all cases from the past that had been filed before it was adopted and all future suits, okay, in which a state was sued by the citizens of another state or by citizens or subjects of any foreign state. So that is Hollingsworth versus Virginia, a very important decision that obviously is still very much good law to this very day, some 223 years after it was handed down. Okay? Very solid case, and emphasizing more than anything the principle, more so than the 11th Amendment per se issue, that the President of the United States officially has no formal role in the constitutional amendment process. All right? Zero role whatsoever. And that the 11th Amendment, okay, applied not only to cases filed before it was adopted, that was still going on, as well as to all future cases fitting that category. All right? In which a state was sued by citizens of another state, or by citizens or subjects of any foreign state. So that's Hollingsworth versus Virginia, ladies and gentlemen, 3 U.S. 378, 1798. If you have any questions or controversies, leave them down below. I'll be happy to answer them. If you gained some insight, some knowledge from this video, drop me a like. I appreciate that. And if you've not subscribed to my YouTube channel, please do so now. Your support means more than you will ever know. Take care, stay safe out there. I'll talk to you at the next video. Peace.